Okay, you're live again.
Call the meeting of the Board of Supervisors back together after a short recess. I need a motion to table resolution number 97
To the March board meeting. To the
to the March meeting. Motion by Supervisor Diamond to table 97 to the March meeting, second by Supervisor Bruno. Discussion. All those in favor signify by saying aye.
Aye.
Any opposed? Okay, that's good. Any other discussion on any other resolutions? Any other roll call votes? Let's vote on resolution.
Oh, I can vote on it.
So it's one, that's been mistake.
Okay. Gonna vote on the rules of the board. Gonna vote on that one first. Did I have to do the vote?
Sure.
Get the vote and then we'll go back.
Okay.
That doesn't need to be a roll. call. Do you want to do a voice vote on it or do you want me to?
Which one?
The rules of the board resolution is 119.
Okay, is that what we want to do first?
Yeah, we can do it by roll call or you can just.
Okay,
Let me know.
go ahead. You want to announce it?
Yeah, so the first resolution, we're gonna go out of order just on this first one. Resolution 119, that's the one adopting the amended rules of the board that speaks to the roll call voting. So Larry had mentioned Attorney Elman mentioned we should adopt that one first.
So we,
It doesn't have to be a roll call vote,
okay,
so you can just.
all those in favor of approving resolution
119.
119, signify by saying aye.
Aye.
Opposed? Carried. That's carried.
Okay, now we start back.
Thank you.
Okay, resolution number 52, making supplemental appropriations. Ms. Bramer? Yes. Mr. Bruno?
Yes.
Mr. Driscoll?
Yes.
Mrs. Frazier? Yes. Mr. Drossy?
Yes.
Mr. Smith?
Yes.
Mr. Dickinson?
Yes.
Mr. Merlino?
Yes.
Mr. Stroud?
Yeah.
Mr. Wild?
Yes.
Mr. McGowan?
Yes.
Mr. Beatty?
Yes.
Mr. Thomas?
Yes.
Mr. Leggett?
Yeah.
Mr. Diamond?
Yes.
Mr. McDevitt?
Yes.
Chairman Garrity?
Yes.
Resolution passes with 865 votes in favor. Resolution 53, amending Warren County budget for 2023 for various departments within Warren County. Ms. Bramer? Yes. Mr. Bruno?
Yes.
Mr. Driscoll?
Yes.
Mrs. Frazier? Yes. Mr. Drossy?
Yes.
Mr. Smith?
Yes.
Mr. Dickinson?
Yes.
Mr. Merlino?
Yes.
Mr. Stroud?
Yeah.
Mr. Wild?
Yes.
Mr. McGowan?
Yes.
Mr. Beatty?
Yes.
Mr. Thomas?
Yes.
Mr. Leggett?
Yeah.
Mr. Diamond?
Yes.
Mr. McDevitt?
Yes.
Chairman Garrity?
Yes.
Resolution passes with 865 votes in favor. Resolution 81, approving 2023 occupancy tax spending plan for municipalities and authorizing agreements for tourism promotion and tourist and convention development services. Ms. Bramer? No. Mr. Bruno?
Yes.
Mr. Driscoll?
Yes.
Mrs. Frazier? Yes. Mr. Drossy?
Yes.
Mr. Smith?
Yes.
Mr. Dickinson?
Yes.
Mr. Merlino?
Yes.
Mr. Stroud?
Yeah.
Mr. Wild?
Yes.
Mr. McGowan?
Yeah, did we jump to 81, you said?
Yep.
Roll, first roll. Yes.
Mr. Beatty?
Yes.
Mr. Thomas?
Yes.
Mr. Leggett?
Yes.
Mr. Diamond?
Yes.
Mr. McDevitt?
Yes.
Chairman Garrity?
Yes.
Resolution passes with 820 votes in favor. Resolution 99. Authorizing the appropriation of funds from the general fund unappropriated surplus to the Department of Public Works budget to cover costs related to the Joseph B. Warren capital project. Ms. Bramer? Yes. Mr. Bruno?
Yes.
Mr. Driscoll?
Yes.
Mrs. Frazier? Yes. Mr. Drossy?
Yes.
Mr. Smith?
Yes.
Mr. Dickinson?
Yes.
Mr. Merlino?
Yes.
Mr. Stroud?
Yeah.
Mr. Wild?
Yes.
Mr. McGowan?
Yes.
Mr. Beatty?
Yes.
Mr. Thomas?
Yes.
Mr. Leggett?
Yes.
Mr. Diamond?
Yes.
Mr. McDevitt?
Yes.
Chairman Garrity?
Yes.
Resolution passes with 865 votes in favor. Resolution number 100, establishing capital project H424 Joseph B. Warren Capital Project. Ms. Bramer? Yes. Mr. Bruno?
Yes.
Mr. Driscoll?
Yes.
Mrs. Frazier? Yes. Mr. Drossy?
Yes.
Mr. Smith?
Yes.
Mr. Dickinson?
Yes.
Mr. Merlino?
Yes.
Mr. Stroud?
Yeah.
Mr. Wild?
Yes.
Mr. McGowan?
Yes.
Mr. Beatty?
Yes.
Mr. Thomas?
Yeah.
Mr. Leggett?
Yes.
Mr. Diamond?
Yes.
Mr. McDevitt?
Yes.
Chairman Garrity?
Yes.
Resolution passes with 865 votes in favor. Resolution 102, authorizing appropriation of funds from the vehicle reserved to the sheriff's department. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll,
Yes.
Mrs. Frazier,
Yes.
Mr. Drossy.
Yes.
Mr. Smith,
Yes.
Mr. Dickinson.
Yes.
Mr. Merlino.
Yes.
Mr. Stroud,
Yes.
Mr. Wild.
Yes.
Mr. McGowan,
Yes.
Mr. Beatty,
Yes.
Mr. Thomas,
Yes.
Mr. Leggett,
Yes.
Mr. Diamond,
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. Resolution 103, authorizing appropriation of funds from the general fund unappropriated surplus to the sheriff's office budget to cover the cost of the insurance deductible in the matter of Frank Dennis versus Warren County. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll,
Yes.
Mrs. Frazier,
Yes.
Mr. Drossy,
Yes.
Mr. Smith,
Yes.
Mr. Dickinson,
Yes.
Mr. Merlino,
Yes.
Mr. Stroud,
Yeah.
Mr. Wild,
Yes.
Mr. McGowan,
Yes.
Mr. Beatty,
Yes.
Mr. Thomas,
Yes.
Mr. Leggett,
Yes.
Mr. Diamond,
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. Resolution 104, increasing capital project H 404 Quaker Road Pavement Preservation Project. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll.
Yes.
Mrs. Frazier,
Yes.
Mr. Drossy.
Yes.
Mr. Smith,
Yes.
Mr. Dickinson.
Yes.
Mr. Merlino,
Yes.
Mr. Stroud,
Yeah.
Mr. Wild.
Yes.
Mr. McGowan,
Yeah.
Mr. Beatty.
Yes.
Mr. Thomas,
Yes.
Mr. Leggett,
Yes.
Mr. Diamond.
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. Resolution 105, authorizing appropriation of fund from the computer reserve to the information technology budget. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll,
Yes.
Mrs. Frazier.
Yes.
Mr. Drossy.
Yes.
Mr. Smith,
Yes.
Mr. Dickinson,
Yes.
Mr. Merlino,
Yes.
Mr. Stroud,
Yeah.
Mr. Wild.
Yes.
Mr. McGowan,
Yes.
Mr. Beatty.
Yes.
Mr. Thomas.
Yes.
Mr. Leggett.
Yes.
Mr. Diamond.
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. Resolution 106, authorizing ARPA funds disbursement to Glens Falls Hospital. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll,
Yes.
Mrs. Frazier,
Yes.
Mr. Drossy,
Yes.
Mr. Smith,
Yes.
Mr. Dickinson,
Yes.
Mr. Merlino,
Yes.
Mr. Stroud,
Yeah.
Mr. Wild,
Yes.
Mr. McGowan,
Yes.
Mr. Beatty.
Yes.
Mr. Thomas,
Yes.
Mr. Leggett,
Yes.
Mr. Diamond,
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. Resolution 107, establishing capital project H 423 NBRC 2022. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll,
Yes.
Mrs. Frazier.
Yes.
Mr. Drossy,
Yes.
Mr. Smith,
Yes.
Mr. Dickinson,
Yes.
Mr. Merlino.
Yes.
Mr. Stroud,
Yeah.
Mr. Wild,
Yes.
Mr. McGowan,
Yes.
Mr. Beatty,
Yes.
Mr. Thomas,
Yes.
Mr. Leggett,
Yes.
Mr. Diamond,
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. Resolution 109, authorizing appropriation of funds from divert revenue sheriff SCAP to the sheriff's office budget to cover the cost of a handicap accessible inmate van. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll,
Yes.
Mrs. Frazier,
Yes.
Mr. Drossy.
Yes.
Mr. Smith,
Yes.
Mr. Dickinson,
Yes.
Mr. Merlino,
Yes.
Mr. Stroud,
Yeah.
Mr. Wild,
Yes.
Mr. McGowan,
Yes.
Mr. Beatty,
Yes.
Mr. Thomas,
Yes.
Mr. Leggett,
Yes.
Mr. Diamond,
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. Resolution 111, authorizing appropriation of funds from the general fund debt reserve and county road debt service reserve to the treasurer's office budget to pay a portion of principal due on bond anticipation notes. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll.
Yes.
Mrs. Frazier,
Yes.
Mr. Drossy,
Yes.
Mr. Smith,
Yes.
Mr. Dickinson,
Yes.
Mr. Merlino,
Yes.
Mr. Stroud,
Yes.
Mr. Wild,
Yes.
Mr. McGowan,
Yes.
Mr. Beatty,
Yes.
Mr. Thomas,
Yes.
Mr. Leggett,
Yes.
Mr. Diamond,
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. And resolution 121, amending table of organization and Warren County salary and compensation plan for 2023 to delete and create positions within the tourism department. Ms. Bramer,
Yes.
Mr. Bruno,
Yes.
Mr. Driscoll,
Yes.
Mrs. Frazier,
Yes.
Mr. Drossy.
Yes.
Mr. Smith,
Yes.
Mr. Dickinson,
Yes.
Mr. Merlino.
Yes.
Mr. Stroud.
Yeah.
Mr. Wild.
Yes.
Mr. McGowan,
Yes.
Mr. Beatty,
Yes.
Mr. Thomas.
Yeah.
Mr. Leggett,
Yes.
Mr. Diamond.
Yes.
Mr. McDevitt.
Yes.
Chairman Garrity.
Yes.
Resolution passes with 865 votes in favor. You just need a collective. on
Just
this.
a collective on the others. All those in favor signify by saying aye.
Aye.
Opposed? Okay. I'll open it up to privilege of the floor one more time. If anybody would like to address the board, and then we'll do the county attorney report. Does anybody have anything they wish to address the board about today? Anybody, please come up and again, your record. Thank you.
Again, my name is Darlene McGraw. I wanted to speak not against something that has been spoken directly today, but something that the town of Lake George proposed last year, allowing the use of e-bikes on certain roadways. I would like the county board of supervisors to look into what the town of Lake George is doing with e-bikes, and also look into how their local law is so that they can allow e-bikes on these roads, because I have rode my e-bike and I could get a ticket for riding my e-bike on certain roadways that go over 30 miles an hour, even though these roads, some of the roads are designated as bike routes for New York State, even though the rules of the road, the vehicle and traffic laws do not state that you can ride an e-bike, whereas, you know, my e-bike can go 10 miles an hour, whereas somebody's riding right next to me with a regular bike might be going 15 miles an hour. They won't get a ticket, but I will. That makes no darn sense. So I would like the county board of supervisors to contact the town of Lake George and look into what the town of Lake George has done and what their local law is, so that you guys can work together, so that people like myself, we can come up here and enjoy ourselves and get around safely and also more environmentally friendly. We want to keep this county green, clean, and a better part of our Adirondack Park and our Adirondacks and the entry to our Adirondacks, so that it can be green and cleaner. Thank you so much, and thank you so much for your time. I appreciate it.
Nice job. Supervisor Dickinson.
Darlene, I'm the supervisor of Lake George. I appreciate your kudos. I'll be the first to tell you that I stole this law from Queensbury. Crossed off Queensbury and put Lake George in, and I would recommend that the county consider doing that as well.
Thank you. Anybody else wish to address the board on public comment?
Talking about supervisors?
And then we're going to do our county attorneys, and then we're staying in, but go ahead, Mr. Lee.
All right, I have just two quick things. Lake George Radio, Walt is here. I have to admit, I was against giving Walt and his company the tax to run his radio because I had never listened to it. And since he got the money from us, I've been listening to it, and he does a lot of advertising for Lake George in our county, and I appreciate it, and money well spent. Second thing, and just want to talk on ARPA for a minute. We're coming to the end, I guess, of what's left in the finances. And I'd like to see if the board would be interested in, let's finish out all the loose ends to it. And whatever money is left, how about we split it by all the counties and and all the towns in this county, including Glens Falls and the mayor of the village. Just take that and divide it, give it to the towns. I think it'd be well spent, especially in the small towns. Thank you.
Okay. Anybody else? And then we're going to have the county attorney's report. Nobody else wish to address it? Supervisor Bramer.
I'll just say one thing, thank you, quick, as an announcement, we're trying to schedule an ARPA meeting coming up very soon, the next couple weeks. The co-chair Dickinson and I are working on a date.
I'll try to be there.
Thank you.
Thank you. Okay, well, county attorney, it's your time.
Great, thank you. Thank you, Craig. It has been a busy month to start off the year in the county attorney's office. I wanted to make sure the board is aware and that property owners are aware that the tax foreclosure lawsuit will be filed before the next Board of Supervisors meeting in March. It'll be filed close in time to the first week of March. So any property owners who are delinquent in their taxes, now would be the time to come in and get them paid before your property gets listed and filed with the county clerk's office for the foreclosure action in 2023. The Board of Ethics did have a meeting on February 9th of 2023. Their next scheduled meeting is March 13th of 2023. Concerning notices of claim, the county has received one notice of claim since the last board meeting. It was received yesterday. It was a notice of claim filed by June Maxim. I reviewed it last night. It's a 8-page document. I would be more than happy to include it to the list of items to discuss in executive session. But I think as far as public comment goes, I am unclear upon my initial review why the County of Warren is named on this notice of claim by Ms. Maxim, based on the contents of the document that she submitted. And I also wanted to note for the entire board that my office, when they receive these notices of claims, these documents, we have a positive obligation under our insurance contract to promptly report them to the insurance carrier, which we will do. The concern is that when we receive notices of claim, which potentially, and I'm not going to refer specifically to the one in my hand, but when we receive notices of claim that really don't seem to have any direct connection to the County of Warren, and we report them, those still affect our future rates as a county. Because the number of claims we file is one of the factors that gets included in fixing insurance premiums. So I guess one topic we can discuss is what actions, if any, we take going forward on some notices of claim. And whether the county, with the consent of the board on a case-by-case basis, whether my office retains it to do the representation, or if we report it to the insurance carrier, which is guaranteed to then be added to the number of claims, which impacts our future rates for a period of years. So outside of that, I'll withhold any other comments about this particular notice of claim until executive session. There were a number of topics brought up at the last board meeting, and also the June 20th full board meeting, which my office has attempted to answer and resolve prior to this board meeting. Two of those, the first one is a question that was asked on January 20th about the creation of new positions and the procedure of the county, and which through the course of substantial research raised the second question regarding the procedure for filling positions in Warren County. If there's no questions on those topics, that's fine. If there is, I asked the board if that's a topic that you would prefer to discuss in open session or an executive session, as it's, while it's attorney-client privilege in the sense it's an attorney opinion, the topic isn't related to some form of litigation or exposure, or necessarily even employment. But I can't waive the attorney-client privilege. It's the board's privilege to waive. And in the same vein, the second of the three questions had to do with the distinguishing between recusals and abstention. So I would include those together and just look to see if there's a consensus or even a vote or motion of the board to waive attorney-client privilege, so those can be discussed in open sessions, or if it's the desire of the board to do it in an executive session.
What's the privilege of the?
I would like to do it in public session, if possible.
We have a motion to do it. Does anybody disagree with doing it in public session? We waived the right. Okay, Larry.
Okay. Well, let's start with the creation of county positions and the filling of vacant positions. This was a really tough issue. And the initial question turned out to be very easy to answer. it's honestly, what does that answer mean for the county going forward? And that turns into the much more difficult question, which I've posed now to the Attorney General's office for an informal opinion and assistance to confirm what we think we see in the statutes that govern. So just as a background, the rules of the board, to include the rules that this committee, that this board just passed today, includes in there a section that's E7 and addresses the filling of vacant positions. But in that paragraph, it also talks about the 2/3 vote that's required in order to create a new position. So the easy answer is that under state law, it's very clear that a governing body of a county may not by resolution modify state statute. And specifically, the state statute that's at question here is County Law 153, subparagraph 4, which says that all matters voted on by the governing body or by the Board of Supervisors will be by majority vote unless the particular statute in question changes that to some other requirement, which would almost always be a 2/3 majority vote. So the basic question that was asked was the resolution that says a 2/3 majority vote is required to create a new position under the rules of the board. Why doesn't that apply when the county approves its budget and the budget has new positions created in it? And that makes it still gives a very simple answer, but it makes the question a little more complicated as well at the same time. And the simple answer is that for years, it seems, and I've gone back to 2009, the rules of the board, which again is a resolution that this county passes, puts in there some form of a 2/3 majority vote, often and for many years, directly tied to the creation of new positions. And what I can say today very clearly is that that provision is ineffective because the board doesn't have the authority by resolution to change the state law that requires a majority vote. And the reasoning is simple. And because the state grants each of you as elected officials on the Board of Supervisors the right to have issues decided by a majority vote, 50.1%, the board by resolution can't just change that. There's a 2007 Attorney General opinion that didn't look on that specific question on creation of new positions, but in general, on a county board that imposed the 2/3 majority vote. And it very clearly said the only way for the Board of Supervisors in general to increase the voting requirement for a class of resolutions or a group or topic of resolutions would be through local law by mandatory referendum. Just to make sure we're all on the same page, that's a local law through the local law process. But then that local law goes on the ballot and is voted on by the population of the county, which in effect gives it the authority and the power to modify the state statute. So one, the rules of the board and the requirement on on creating new positions by resolution by 2/3 majorities vote. We should not, my legal recommendation is that the Legislative Rules Committee and the committees look at that and decide to take action on it to modify or further modify the rules of the board to conform with state law. So what's the more difficult question? The more difficult question is, how does this board, if they choose to continue to require a 2/3 majority vote when they create a position, what's the process or procedure that the board would need to use to put that back in place legally? It may be through that local law by mandatory referendum process, which would put it out to a vote countywide. And this is where I asked the AG to hopefully provide us an informal opinion. Because there's a difference between creating positions under the budget, because those are all state statutes. That's Article 7 of the county law. And there's an incredibly precise set of statutes that lays out step by step what our budget officer and what this county as a whole does from August into the end of December to create the appropriations resolution for the final following year. And it does not, I can't tell or find any guidance that a local law by referendum would permit a 2/3 vote on the budget, because the budget statutes clearly say it's a majority vote. And it's an entire scheme that covers multiple statutes that lays out the entire process. And I'm asking the Attorney General to go back to their 2007 opinion and apply that to Article 7 of the county law to give us some guidance on, is it a majority vote, or does a county have the ability to increase it for certain portions of the budget? I suspect, but I can't provide a firm opinion, that a county does not have that ability when it comes to a budget and line items in a budget. But hopefully we'll hear back from them in the near future. The second area is, well, what about the creation of new positions outside of the budget process? And is that local law by mandatory referendum the only way to get to a 2/3? And again, I think that's going to be a little clearer. And the answer, I think, to that's going to be yes. Without that local law by mandatory referendum, the county cannot impose a 2/3 voting requirement on a class of resolutions, which would be the creation of new positions. Now, in the process of digging through all of the statutes and guidance and regulations, one of the statutes we looked at carefully was Public Officers Law 204. It's a very important statute because it's the statute that gives to this body, the Board of Supervisors, two very important and clear powers. It's this board is the only decision-making body that can create a new employment position in the county. And it's the only body that can abolish a position that's been created in the county body. And I would suspect that 20 out of 20 supervisors would basically look at me and say, yeah, no doubt, we know that. But underneath it, and the last sentence of that statute is what our attention was brought to, which is why we include the secondary topic of filling existing positions. Because that same statute that gives this board those two very specific powers, creation and abolition, the last sentence says, and I'll paraphrase it, that it is the department heads of a county that are responsible for filling a vacant position, meaning a position that's in the current year budget that's been approved and that exists. Which brings us back to that paragraph E7, which is dedicated to filling existing vacant positions, which imposes upon the department heads of this county a series of additional measures and steps before the department head can fill the position. So just take, the hypothetical, not to pick on any departments that have a lot of fills, but Department A. If Department A has an employee that's in there, obviously it's in the budget because they're working and getting paid, and that employee leaves employment today, per 204, the state statute, it appears to say that department head can immediately fill that position, which is also contrary to the resolution, which is the rules of the board, that adds on additional requirements before that department head can fill the position. I included that question in the request for an opinion from the Attorney General's office as well. again, I don't want to give a firm opinion today, but on that one, I am siding much more with the statute that clearly says it's the role of the department head to fill a vacant position and not the role of an example for this rule of the board, the approval of the county administrator, the approval of the committee head, and the affirmative vote of the committee before they can fill a position that's already been approved by the board. So that's the rationale, I think, behind the statute. And how all of these statutes, the finance and the budget appropriation statutes, the public officer law statutes, all meld together to create this functioning system of how do you create positions, how do you abolish them, how do you fund them, and how do you fill them? I pause to take a deep breath. Are there any questions on that before we move to another topic?
There is one.
So in summary, to make sure it's not, maybe it can be as clear as murky water. The rules of the board requirement for a 2/3 majority vote to create a new position is contrary to state law. I will get back to the board on an answer from the Attorney General's office on what the process or procedure would be to impose that requirement going forward. And it's a question of, it's a two-part question. What's the requirement in the budget process? And can you do it in the budget process? And the second question is, outside of the budget process, what's the procedure to create that requirement? And I believe the answer is going to be local law by mandatory referendum.
Oh, go ahead.
Thanks, Mr. Chair. So basically, if the county residents, if we brought a referendum to the county residents, they would vote on whether, hey, do you want 2/3 to approve new positions in Warren County or not? They'd vote a yes or a no. And I'm fine with that. You know, I think the county residents should have a say whether they over a majority should have a say whether a new position should be created or not. I think that's good fiscal responsibility on our part to bring it to them to make that decision. If they say a simple majority via the vote, then that's fine too.
Well, just to clarify, they wouldn't be saying a simple majority because that's the statutory requirement right now.
Yeah.
And I don't weigh in on the political question. And what I mean by political is what your job is as supervisors to decide is what's best for the county. I'm just weighing in on what I see from the legal perspective of what's authorized and what would be the process. And I still, again, until we get some response back from the Attorney General to help clarify what's kind of unique on this situation, meaning the budget process versus outside of the budget process, I would ask the board just to refrain from moving forward on one local law by mandatory referendum until we can be absolutely sure what that means, obviously, and what the scope of that would be, i.e. outside the budget process, I think. Second was on recusals and abstentions. Again, I thank the board for providing my office the opportunity to expend a tremendous amount of time on these two topics, because they both were far from clear in the details, while the overall general rule is fairly easy to nail down. So in short, for Warren County, under the rules of the board, there is no abstention. So when a matter is coming, when a question is before the board, for example, a resolution, county supervisors do not have the authority to abstain, meaning to decide not to vote on that question. And that's because under the rules of the board, this board has enacted Rule E1, which simply says all members present shall vote upon each question. And the fact that this board has enacted that rule means that you don't have the individual authority as an elected officer to decide when you want to not vote. So that's part one. Part two is when is a recusal from voting appropriate and how should that be handled? And a recusal is a very specific and very limited requirement on each member of the board to not vote when there is an actual and in some cases, an apparent conflict of interest, meaning the matter that's coming before the board involves an entity, possibly an issue, but more likely an entity that the supervisor knows they have an actual conflict of interest on. Now, with that said, how do you know if you have a recusal issue? Well, my off-the-cuff answer is if it's on your financial disclosure statement, then you shouldn't be voting on it. And if it's on your financial disclosure statement and that entity or that item comes before the board, you as a supervisor under state law and under the Warren County Code of Ethics have the affirmative obligation to recuse and not participate. If a supervisor is seeking to recuse from a question that's presented, and because of the entity that's involved or the issue that's presented, and that entity or issue is not on your financial disclosure statement, I will go that further step to say, you need to update your financial disclosure statement. And I'm hoping that the way I'm approaching this is helping each of you see that what a recusal is really, hey, it's a conflict of interest because I have this interest in this outside entity. I'm either employed by them, I get money from them, I have a family member that works for them. And I know I report that on my disclosure statement each year. So therefore, when those issues come before the board, I can't vote on. So it's not a preference, it's not a desire, it's not a political statement. It's an actual conflict of interest, which is when a member of this board must recuse from participating in the proceedings on that question. Are there any questions about that before I talk about procedure on recusals?
Oh, yeah, I have a question. So if I'm part of an organization that the board may be giving money to or something, is that a recusal? Even though I don't take money from the organization, is that a recusal? I mean, we used to abstain from voting if, say, different supervisors were on board of directors as something we're going to give money. So is that, are we saying that's a recusal or what are we saying now?
My safe answer is if it's on your financial disclosure statement, it's not something that you should be participating in front of the board. And the reason I give my safe answer is because Article 18 of the General Municipal Law is very clear, but complicated in the sense that there's a large number of exceptions. Many of those exceptions apply to not-for-profit entities.
Yeah, that's right.
So we would need, my office and myself would need to work with the supervisor on a case-by-case basis if you have questions on that. Generally speaking, not-for-profits are excluded, but I don't want to answer off the cuff on a particular supervisor's concern or question. But please reach out to me before the next board meeting and we'll look at that particular concern and whether it would be in fact a recusal matter from voting. And with that said, I guess the next question is, well, what's the process or procedure? Oh, go ahead.
Yeah, before you go to that, could I just ask a question? In your memo to us too, you talked about how there was case law saying that even if we don't have a rule such as what's in our rules of the board, we shouldn't be abstaining anyway. I guess there's not really a question in there. That's correct. And, I want to point out that there have been times where I've abstained because I feel like I don't have enough information, or I am not sure of the procedure or the process or whatever. You're saying we shouldn't do that anymore. We just either vote no or say nothing?
You vote yes, or you vote no. Or you recuse yourself because you have an actual conflict
Well,
of
that would-
interest as the board, as the
Recusal,
rules of the board exist.
right? We don't, if I have not an actual conflict, I shouldn't recuse for some false reason.
That's absolutely correct, because
Okay.
that's why I refer back to the financial disclosure statements that are filed. Because the basis for the recusal should be on that disclosure statement. And, I don't know how far you want to go with that analysis, but if somebody recuses, if a board member recuses on a vote, the question becomes, well, if the Board of Ethics looks at that financial disclosure statement and they don't see that there's a conflict reported on it, is there a issue with that filing under the Code of Ethics? And arguably there is, because the board member is affirmatively recusing due to their belief that there's an actual conflict that they have not reported on their financial disclosure statement. Now, that's not perfect, right? There's always gray areas and everything, but I think as a general rule, I would encourage not just the members of this board, but every county employee who files a financial disclosure statement as they live their lives, literally, to keep in mind your involvement with outside agencies and whether that's creating an actual conflict under the ethical rules that need you to update your disclosure statement.
I just have just one quick one. Like,
Sure.
I think most of us who have been on the board at one time or another, maybe abstained one time. Is this a new rule that's in our boards that we shall vote and it must be a yes or no?
I believe that rule's been there. I saw it back in at least the 2010 version. I don't want to misstate the year, but it's been there for a while. But I'm going to state what I always state individually to each of you, to department heads, to whoever it is. Until my office looks at a specific issue during my tenure, I'm not going backwards in time to what happened before. I'm also not saying that's the way we've always done it, so it must be right. But we're going back to the basic foundation statutes, working our way forward to see if it makes sense and if it's right. So really, I guess from my perspective as legal counsel to the county, what's the rule now? And now the rule clearly is under state law, regulation, and especially case law, which really comes down hard on some situations when people do this abstention. And the abstention is really a method of blocking a particular action from occurring. One court, I think it was in Long Island, a Supreme Court, basically took the affirmative action of saying, hey, it wasn't a supervisor, it may have been a town, I don't remember specifically, but every abstention, the court said, I'm treating that as a yes vote. And it went back in the record and by judicial order, passed legislation that had been coming up in front of that board based on flipping the abstention to a yes vote. So it's pretty, it can be, because we have 20 supervisors and the number of votes you each carry, that's, something that extreme seems unlikely. But I think having that in the back of your head is important to really understand how important this is. And courts view this act of voting. And again, it's kind of like, I go back to being a kid on Saturday mornings and, learning about what happens to a bill on Capitol Hill. The act of voting is your primary obligation as an elected official. So if you're not, and this isn't me, this is the courts. If you're not exercising your primary obligation to vote, are you undermining the trust and confidence that the general public puts in you in placing and voting you into the position that you hold? And that's not just this board, that's across the board for elected officials. And that's in case law that looks at this issue.
We have Supervisor Beatty, Supervisor Driscoll, and Supervisor Wild. Y'all had your hand up.
Yeah, So you shall vote. So when a supervisor gets up and leaves for a vote is not counted. What happens then? I guess, you know, you come in, you sit down, sometimes supervisors get up, they have to use the restroom, they have to eat if they're diabetic. So,
Well, let's go into procedure, okay? Because there's an answer to that, and the answer is that's up to the board. So the procedure that I'd recommend the Legislative and Rules Committee looks at going forward is a tweak on the rules of the board, to just add in after the reading of the resolutions, a call for recusals. It's as simple as the clerk of the board at that point, before there's any discussion or debate on any resolution, asking the entire board to identify which resolutions they must recuse themselves on. Because what recusal requires is very clear. If you're not supposed to participate, when that issue comes up, you need to stand up, you need to leave your seat and exit the room until the discussion is ended. So by identifying upfront which resolutions individual supervisors have a conflict on, the discussion and voting can be structured in such a way as to provide those supervisors the opportunity to stand up, exit the chamber, and then return when the action on that resolution's completed. I don't think that's going to happen very often, but when it does, it's important to follow what the rules and the requirements are. As to the more direct question of you're not recused, but you got to get up and leave. Let's be creative. Does the board need to take a 5-minute break before it starts the debate and voting on resolutions so that everyone remains in their seat? I've seen some case law and or rules that says a member can be required to return to their seat or stay in their seat. So if you're going through the process of voting, and the process of voting doesn't take that long. It's the debate that could potentially take quite a while. But the process of voting on those resolutions is usually a fairly tight timetable. And that's a time where, again, based on case law and statutes and research, everybody should be in their seats and complying with the rule of the board that says all members present shall vote upon each question. Now, how draconian do you want to be? Obviously, somebody's got to go to the bathroom, right? We're not in elementary school. If somebody has a medical reason, right? But in general, I think there's a way to tweak these rules so they're clearer for everybody, so that every member is doing what they should be doing as an elected official to the board.
Okay, Supervisor Driscoll's next and
Chairman, this is real good information, Larry, but I think many of us may have specific questions for you. Are we going to be overloading you if we kind of request a date and time when we can come down and kind of present our laundry list of concerns? I know over the 5 years I've been on the board, there's been certain specific issues that come up every year, whether it's having a spouse who's employed by the county. Sometimes I have to abstain or recluse. Sometimes I don't after consulting with counsel. I kind of like in the next few weeks or something like that, just to kind of, I can even share that with you. Some of my questions and at your convenience, you could get back in touch with me. I don't know if others feel the same way.
It's a core requirement of the county attorney's office to assist the supervisors in those issues. So it doesn't matter what our time requirements are. We'll get you in, we'll sit down, and we'll go through it. I may not have an off the cuff answer depending on the issue,
Right.
but we'll address it.
Okay, great.
And we'll address it going forward. I'd rather everyone to know and ensure that they're complying with conflict of interest law in the state of New York than to have a question in their back of the minds and not ask.
Supervisor Well.
Thank you, Mr. Chairman. Just a comment. A couple of years ago, we redid our total financial disclosure. Instead of following what the state does, we dropped it down to a bunch of questions that I think most of us just said not applicable. At the time, I voiced my opinion that I thought that was a violation of public trust. It's for the public to make sure that we don't have a conflict of interest. We're not profiting potentially from something like this. I would respectfully ask our attorney to evaluate the effectiveness of our current financial disclosure form and provide recommendations, if necessary, to how we might update that to make sure that people that have possibly, I say I have a relative in my family that has a business that does work with the county. That doesn't exist anymore in the financial disclosure form. So if you could take a look at that, if that's possible within all the things we give you, I'd love to hear back.
What I'm gonna ask, and I have no problem with that, to the supervisor from Queensberry. But going forward, and it became apparent this last cycle, that individual supervisors may have a issue or question that's very pressing and important. And I have no problem with my office addressing it. I would just ask that that question be presented to the entire board, as whether the entire board thinks it should be addressed or the committee thinks it's going to be addressed, because one thing I guarantee is my office cannot respond to individual questions of importance from 20 supervisors. Getting through the 3 questions that were posed in the last 30 days, in addition to what we normally do, we did. But I'll be blunt, it was very time consuming and other things just didn't get done. So I'm not saying we won't, I would just ask that there be some acknowledgement by the entire board that the entire board deems that appropriate. I will definitely look at the question that was just posed, but going forward, we just need to tighten up so that a supervisor can't just say, hey, I'm interested in blah, 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 go look at it.
Right.
I don't even need them in writing. I just need to know that the board, there's a consensus on the board that they want the county attorney's office to spend time doing it. And I don't want that to apply to that request, but going forward. That's all. That's all. Just something to consider, because it's hard for us to do. There's a large number of things that my office does that you never see. And it's hard to do all of those things and try to stay on top of what this board wants.
All I'm saying, if 5 people have the same question, you don't need 5 different people asking it.
Absolutely not. I
So
just need to know there's.
We have to give it to the administrator to try to collect them and put them in some form, and then we can get them answered. I mean, I have questions. I'm sure other people have the same questions. We can go through, John?
Thank you, Mr. Chairman. This brings up a point that I wanted to bring up as well. So I'd be willing to take those questions and compile them. We have a similar issue with our department heads, and I appreciate that all of you have great relationships with our department heads, and I appreciate that you make an effort to speak with them and you make an effort to talk to the people who work with them. But a lot of our department heads have brought it to my attention that they often get questions or directives from individual supervisors that they have to respond to, and they feel they have to respond to. And I think that's part of their job. But sometimes individual supervisors give directions that are in conflict with what the committee may think or what I think the board may think. So I'm asking you to come to me with those issues if you're not on the committee, or speak with the committee chair, to direct the information to the different department heads. I want you to still have relationships with them. The same point that the county attorney's making, like to funnel everything probably through the county administrator's office, and I'll make sure that we take action on types of things.
We haven't had a chance to discuss this, but I partially disagree because I'm appointed by the board and I'm your legal advisor. My point was much more, the department head issue is a separate issue. My point is when we're in these meetings, we've gotten into a habit of supervisors just kind of tasking me to do something. And I'm okay doing that as long as there's a consensus on the board that that's something that we should be spending our time on. That's all. That's all. And on a one-on-one basis, please reach out to me. But again, I can't respond to the individual requests of 20 supervisors.
Supervisor Bramer.
Thank you. I just wanted to point out on the financial form, it does say, does any relative currently work for Warren County? And then the other questions talk about financial interests, whether you or any of your relatives have a business position or have outside employment or receive money through an organization that does business with Warren County. So I think that that question is covered and you should be disclosing that on your form.
Yeah.
The second thing I just wanted to ask our attorney is, I know you had written up a legal memo about the recusal thing, and I'd like to be able to put that out on the public website. We discussed the contents of it. I think we waived the privilege. I'd like to put that out there, as well as whether you wrote one on the other thing, the board budget creation of new positions.
I think if the board takes an affirmative vote to waive attorney-client on those two documents, then we can certainly post them out on the attorney-county.
I think it would be helpful for the public to be able to read it as well as.
I think we need a motion
That's it.
on that. I think we need a motion on it as far as, because it's a,
Okay, we have a motion.
I'll make that motion.
Supervisor Beatty, second by Supervisor McDevitt. Any discussion on putting them on the website? Supervisor Stroud.
Well, and I believe there's another county attorney opinion that deals with employees and elected positions.
Mm.
And I believe that may be the next discussion item.
well, if we can address that in executive session.
Okay,
I've reserved the other three topics for executive session when we get to that.
These are on just these two.
okay.
Okay, all those in favor, signify by saying aye. Anybody opposed? Okay,
Thank you.
One last topic before I ask for a motion for executive session is the administrative team is looking for guidance from the board on a particular issue. And the issue has to do with the county's harassment and discrimination policy and how we process and deal with complaints that are filed when the subject matter of the complaint is a supervisor. So shortly after I started, we made amendments to the workplace violence policy so that we had the ability, or the board had the ability, to review a complaint that was filed and to take action, if appropriate, on a workplace violence complaint when it dealt with a complaint against the supervisor. Under the discrimination and harassment policy, the Director of Human Resources and the county administrator are the two officers that are appointed or designated to do the investigation and to take corrective measures. And that works for the entire county except for this body. Because neither the Director of Human Resources or the county administrator has any ability to take corrective action if corrective action is required when the complaint's against the supervisor. So I because this is a policy question, and I don't want to go into any specifics in open session, I'm just looking for some guidance from the board as a whole. If there's a desire to handle these matters by having them presented to the board for a determination when it involves a supervisor. Because if that's the case, then we would move forward and have some further work to do amendments and modifications to the current policy to provide that additional process and procedure. If and when these complaints come in.
I don't know.
So
All right,
We'll have to think about that. Can we think about it?
absolutely. And I guess we'll go into maybe more specifics in executive session.
Okay.
I also just wanted to make the board aware, then last month, we talked about assigned counsel.
Yeah.
And that we were starting to receive orders to show cause with individual members of the panel seeking to increase, asking the court to increase their rate from $75 to $158. Since the last meeting, my office has received 4 more orders to show cause. 3 have been completed. Our opposition to those motions have been completed and filed. The 4th one will be done in the next week or so. But you know, what was 1 is now 4, and I hate to think how many we're going to get in the next 30 days if this is something that is going to be a form of protest or actual request by panel attorneys going forward, because it takes significant time and resources to respond individually to each of these requests for heightened fees. And the reason the county is opposing it is because there's absolutely no legal statutory basis to change the statutory rate from $75 to something else. The board has already heard and may be aware that there's a proposal in the governor's budget to increase that amount. But unless and until that becomes a new statute, 75, our office is taking the position that the statute says what it means, and that's the rate that applies. With that said, I would ask the board to go into executive session. Shoot, I left one thing. Well, I'll do it in executive session. One, to address matters under Public Officers Law 1083, which are confidential by federal or state law, concerning rehiring retired county employees, holding a position as an county employee and a supervisor at the same time, as well as if there's any questions regarding FOIL requests and occupancy tax returns. On personnel matters, there's one matter I'd like to address with the board under the harassment and discrimination policy, and a complaint that the county has, as well as potential litigation that may be coming soon against the county. And that would be under section 105(1)(d), a discussion regarding proposed, pending, or current litigation.
Motion to go into executive session. Motion by Supervisor Bruno, second by Supervisor Stroud. Discussion. All those in favor? Aye. Okay, we're going into session. I appreciate everybody